All right, welcome everyone to the Ask a Lawyer series. And today's topic is on estate planning. This webinar series is a collaboration between the Sacramento County Public Law Library and HERA, which stands for Housing and Economic Rights Advocates. Throughout the webinar, please feel free to type your questions into the Q&A box. And I will try and address those questions at the end of the webinar. If you would like a copy of our slide deck or the recording of the webinar, please feel free to text your email address to the Q&A box as well. And only the host will be able to see your email address. It will be a private information. It will be kept private. Disclaimer, please note that this presentation is for informational purposes only and does not create an attorney-client relationship between the participants and either the Sacramento County Public Law Library or the Housing and Economic Rights Advocates. More information on additional resources will be made available to you at the end of the presentation. All right, today we will talk about estate planning, and it's more of an intro. So title is Estate Planning 101. 101. HERA, Housing and Economic Rights Advocates, is a California statewide nonprofit legal services agency, and our mission is to ensure that all people are protected from discrimination and economic abuses, especially in the realm of housing. HERA provides free legal advice and counseling for tenants, homeowners on all topics related to foreclosure, including difficulty faced in working with servicers, relief from loan modification scams, and post-foreclosure debt collection. Today, we will talk about the WH questions: what, who, when, why, where, related to estate planning. First, we will go through some true or false questions, and these are common things that we hear from clients and the like. So first of all, first question, whether it's, well, first statement, you can determine whether it's true or false. I do not own anything, therefore I do not need estate planning. Typically, if we have the chat box enabled, we will have attendees put in their answer. But here you can kind of think about it for a minute and have the answer in your heart. So this is actually false. Even if you don't own much, or you feel like you're really young still, estate planning is for mature adults. It's actually not true, but estate planning is for everyone, which we will learn later. The second statement, I have 3 children, Omar, Oscar, and Olivia. I can leave my house to Oscar only. Is that true or false? That's actually true. You will have the freedom to instruct in ways that really suit your needs and desires in your estate planning documents. The third statement, I have a written will. My child does not need to go to probate court when I die. This is a little tricky because this person has already done some estate planning, but it's actually not true. Even with a written will, descendants inheritance will still have to go through the probate court if there is no trust. We'll learn about more of that later in the webinar. Yeah, so the judge will determine who your beneficiaries are, whether your will is valid or not, and it will examine your terms in the will to see who they are and so forth. Next one, my children get along so well, so I don't have to worry about anything at all, right? So that's actually also false. All right. So what is estate planning? Estate planning is a process. It's not only a set of documents, it's a process. It involves people and property, your loved ones and your possessions. And it also addresses your future needs. A will, which we may hear about the most, is a part of the planning process, but you need further documents. You need other documents as well to fully address your estate planning needs. Typically, estate planning documents involve these things that are on the screen. And some of them are there to take care of what our inheritance planning needs are, and some of them are there to take care of during my lifetime. What do I do if I lose my capacity? So there are documents called the Durable Power of Attorney and also Advanced Healthcare Directive. So these two documents we'll learn later in more detail are there to take care of capacity, well, incapacity planning. So if I one day lose capacity to manage my own affairs, what can I do? Who can help me? And then there's also trust and will. And these documents are inheritance planning documents. They take care of who get my stuff after I'm no longer around. Why do I need estate planning? So as I briefly touched upon, it's for two primary purposes. One is for your incapacity during lifetime. You can designate someone, an agent, to manage your assets and also to help make healthcare and personal care decisions when you become unavailable or unable to do so for yourself. And the second main purpose is for post-death planning. You can be the one to determine what happens after death while you're still alive and well. So because there are these two main purposes, we will talk about them one by one. So first, we'll talk about inheritance planning documents when you're gone. So what happens after we pass away? A process called probate happens if we don't have sufficient estate planning done, or even if we just have a will. So there are probate code sections that talk about the specifics of the probate process in the probate court. So there's a number here for estate. Estate is all the things that we have at the time of death. Estate not exceeding $184,500. So this number is the gross value sum total of everything that we have at the time of death. And so if we have everything combined, the value of everything combined is over this amount, then the probate court will take interest. So imagine any homeowners, especially in California, if you have a home, obviously it will tipper that value amount. And again, it's gross value. It's not just equity in the home. And so the date of valuation is date of death. That's the date that the value of that date matters. So this is the asset subject to probate. But there's also assets that are exceptions. So they're not subject to probate. So there are different kinds of assets that the probate court will not consider. And they're here in these bubbles. So first one is property held in the decedent's revocable trust. So we hear about living trust, revocable trust all the time, and we will talk about this primarily today. And the second one is properties, real properties, so houses held in transfer on death deed. And well, this is a deed that looks similar to a grant deed, but it's called a transfer on death deed, and we'll touch this again later also. And the third one is multiple party account, pay on death, POD, pay on death account, or total trust account. So when there are multiple people owning the same piece of property, multiple people being on the same account, and so as long as they are still on the account together, when one person passes away and there's still survivors on the account, this property is not subject to probate. And then the fourth bubble here says the value of your property altogether is less than $184 and $500 altogether. So if everything that you have together, the gross value is less than this figure, then the probate court will not take interest. And then the lower level bubbles, the first one is properties held by the decedent in joint tenant or joint tenancy. So you see the wording on grant deed of the house sometimes, husband and wife as joint tenants. And so this is also the last survivor of will own everything. So until we have everybody on the title pass away, there will not be a probate happening. And the next one is property passing to surviving spouse or registered domestic partner. So it's similar to the joint tenant that we just talked about. This is just specifically to married people or registered domestic partner. And then the last one is retirement or death benefit property with beneficiary designated. So 401k, 403b, when there's designated beneficiaries already listed in a very clear manner, this property will also not be subject to probate after the owner passes away. So as you can see, the logic kind of is behind the probate court is the probate court is just trying to protect the interests of the decedent. So when there are these other arrangements that's made and it's clear where the property should go after the original owner passes, then the probate court will not take interest. So today, as I said, we will primarily talk about the revocable trust, which is in the first bubble. So there are these terms that you will encounter in the revocable trust. They're important parties. So in general, there are three parties. Settlor, which is also called grantor or called trustor. That's the owner of the trust that sets up all the terms. And trustee is the person that's handling and managing how the properties should be designated according to the trustor's intent that's laid out in the trust. And then beneficiary, which is the party that receives the inheritance that benefits from the estate planning. And then you see revocable or intervivals or living trust. Intervivals and living here means the same thing. And you see pour over will, which works together with the trust. And there are also common provisions that identifies the family members and talks about trustee and successor trustee. So the successor trustees are the backups. So when the first person that's designated is not able to act, then the successor trustee will step into the first trustee's shoes. And there's provisions on distribution, and it may have specific gifts, $2,000, a particular car, or not, and the residue, which is everything else the trustor owns. And there are different provisions on trustee compensation, how accounting should be done, and the spendthrift clause and no contest clause. And these are clauses that kind of protect or maintain the family peace. And advantages from trust. Sorry, let's go back here. So I mentioned briefly, if you have a will and no trust, still a probate is needed unless everything that you have is below that 180 something dollar amount, which is not common. Usually people have more than that. So if you only have a will, the judge at the probate court still wants to see if the will is valid and the circumstances surrounding how the will was executed. And the will also is a public record. So you hear stories of famous people passing away and their will going through the probate court will be available to the general public. And if you have a living trust done properly, living trust, very contrary to the will, is a private document. You don't record that anywhere. You when you sign it, you have a notary present when you sign it, but it's not publicly recorded. And once the judge is notified of the existence of the will, there is no probate needed from that point on, because your intentions is already laid out in the trust. And there are many other differences. So if you have to go through the probate route, having only the will or nothing at all, then there's statutory compensation in California to the personal representative and their attorney. So it's determined by how big the estate is, and the more you have, the bigger the statutory compensation, that compensation by law is to whoever is named as the personal representative or that person's attorney, and the person's attorney. For people who have living trust done, there is no statutorily guaranteed fees to the successor trustee and his attorney. So that's a big difference there. And also when so under the trust context, the person that's taking care of matters is successor trustee. And under the will context is executor. There's similar roles, but if you go through the probate process, you're obviously under court supervision every step of the way, and there are deadlines and fees. But if you don't have to go through probate, when you have a trust and successor trustee take care of matters, they do everything without court supervision or approval. So it could be more, it just saves more time and money in general. And another major difference is asset recovery. So for Medi-Cal recipient, after January of 2017, if you have assets held by the living trust, for example, the house transferring over to the trust, that is considered property not subject to probate, which we just talked about. And that also is protected from Medi-Cal recovery. So that's also a major difference. If you then have no living trust and the house is owned by you personally and you have a will or no will and have to go through probate, that piece of property is still subject to estate recovery or Medi-Cal recovery. So all in all, on the living trust side, at the end of the day, you just have more money for designating to your beneficiaries, and the process is usually quicker. on the probate or will only or no will side, you have less money at the end because of that statutory compensation that we mentioned, and also longer time because of the court supervision along the way. And if you have no will, there is a set kind of like a formula determining who the order that people take or people inherit, and you might have assets going to people that you would not want, which we will talk more in later slides. So that was a lot about living trust and the advantages of trust. Now we talk a little bit about will. So what is a will? A will contains your wishes and desires, and mostly about who receives your possessions after you're no longer around, and also who will be the point person to see through that process. And with a will only, probate is still needed, and court authorizes the distribution of your assets according to what you have put down in writing. So probate is, like I said earlier, a court supervised process, and it's to determine the decedent's estate, and who should be the beneficiaries according to the will or according to the law, and also whether the will was valid or not, and the court will appoint a personal representative to take care of matters. And if no will is ever done during lifetime, then distribution will be made according to the probate code, like the formula that I mentioned earlier. So this is the probate code section that talks about the order people receive or inherit if there is no will. And it's a long list, and it's by the order of spouses, and then if spouses are not around, then children. If they're not there, then grandchildren. And if not there, then other descendants. If they're not there, parents, kind of like that order. And if all of these people are not around, it might even go to creditors or any other person, which is the red part at the end. And that's usually not people's intentions. And this similarly, this is just a table that talks about the same thing. It has the numbers here, 1, 2, 3, 4, 5, 6, 7 is the order where how people inherit. And it's by degrees of relationship. And this is a chart from the Alameda Court probate court website. And the exact content here is not the content. It is not something that we're trying to talk about. So you don't have to zoom in and see the nitty-gritty details here. But this is just to illustrate how the probate process could be quite a marathon, and it has a lot of like dates and deadlines and steps that personal representative have to go through to move the process along, and that's why probate could be lengthy and costly. And this is the table for statutory fees. It could be a little different now, but it's the idea of the probate fees that if you open probate for the decedent family member, you will have this burden owed to the personal representative and also the attorney that's involved, and it's calculated by the estate size. The more the decedent owned, the larger the fees. And I think it's relatively usually around 4%, I would say, and it's less percentage as the estate size grows, it's a little complicated how to calculate it, but it's much more than if you have a living trust done, and there is no legally required fee for the successor trustee. So for example, if say when you pass away or when the decedent pass away, that person's gross asset value is $1 million. That's just a round up number, it's easier for illustration. And say if there are, it's a house. So this person, that person owns is a house, and there's $300,000 that's still the mortgage that's not paid off yet. The net value or the equity is about $700,000. So on the trust admin, so on the chart on the left is as if this person had done estate planning and had a will and trust done during lifetime. The let's just say the cost of administrating this trust, putting advertisement about selling this probate, real estate and all these costs together is $20,000. The balance of that will be around $680,000. And then there is no legally required fees to attorneys or trustees. The distribution that you have available for the beneficiaries starts off at around $680,000. And on the right side is if there is no living trust and the probate is necessary, same fair market value, say a house that's worth $1 million, same encumbrances for unpaid mortgage, $300,000 left, and the same net value or equity on the house, $700,000. Same cost of admin posting on Redfin or other costs related to really liquidate the asset, $20,000. Same balance, $680,000. There is statutory fees owed to the personal representative and the probate attorney. So together, they eat into that the $680,000 balance, and it only leaves you with $634,000 to distribute to your beneficiaries. So again, that illustrates the differences between no probate versus yes probate, and the advantage of having the living trust done. So here's a little fact pattern, and let's say we have someone called Pamela, and we're trying to see if probate is necessary for Pamela's estate. So Pamela passed away on March of 2018, and she has left behind these assets: a house that's worth $300,000, titled as Pamela, trustee of the Pamela Trust, dated Christmas of 2007. And then the second piece of property is the IRA account that's worth about $145,000 in total, naming Ben as the beneficiary. And the third piece of property is the life insurance policy, naming her elderly mom, Stella, as the first beneficiary and younger brother, Leo, as the second beneficiary. Stella predeceased Pamela in 2016. The fourth property is checking and savings account that has about $2,000 in balance, and naming Pamela's boyfriend, Tommy, as the beneficiary. Do you think probate is necessary when Pamela passed? Gonna go to the answer, which is actually no. No probate is necessary because the house is transferred over to her trust and her retirement account has a clearly designated beneficiary, then her life insurance had two level beneficiaries designated, even though Stella, her mom, predeceased her. The second level beneficiary, Leo, was still alive. So he's able to take the life insurance proceeds without probate. And the checking and savings account naming Tommy as the beneficiary, and no probate is needed for that either. Next, we have Alex. Does Alex's estate need probate? Alex died on the same day as Pamela, leaving behind these assets: a house worth $300,000 titled in Alex, an unmarried man, and his 2 IRA account with no beneficiary designated, his life insurance naming his elderly father Sean as the first named beneficiary, and no second beneficiary was named, and Sean predeceased Alex in 2016. Checking and savings account that has about $2,000 in balance, naming my girlfriend as the beneficiary, and about 20 people claim to be his girlfriend. So is probate needed for Alex's estate? So the answer is yes, because all of these properties are actually subject to probate. So that was all that we had for living trust and will. Earlier, we talked about different properties that are not subject to probate, and one of them being real property held in transfer on death deed. And this is a somewhat special product in the state of California, and I believe some other states might have this also, but it's not everywhere in US yet. So transfer on death deed is could be understood as a more simplified estate planning process, and it's best used in a more urgent situation when someone's on their deathbed, and doing the whole trust might be not very practical from a timing perspective. Transfer on death deed is a piece of the deed document, and it has a area to name your beneficiaries, and you can designate your beneficiaries for this property, this real property that you own, using the transfer on death deed. And it has its limitations and problems, and so it's definitely not a replacement or substitute for the traditional estate planning through living trust, but it is one way to do estate planning for the real property, especially in urgent situations. So there are eligibility requirements for the real property that you own. So it couldn't be large residential dwelling for more than 4 units, for example, and it couldn't be some, there's like limitations on agricultural land. If it's more than single track, it also might not be eligible. And it also has formality requirements. When it's signed by the homeowner, the beneficiaries have to be identified by name clearly, and also you sign it in front of a notary, and it has to be recorded in the county recorder's office within 60 days after notarization. So that's a very strict requirement there, specific to transfer on death deed. And when you later say change your mind and you want to revoke the transfer on death deed, there's same formality requirements for the revocation document as well. So in order for the transfer on death deed to be valid or validly canceled or revoked, you have to meet all these eligibility and formality requirements. This is what it looks like, and it looks similar to the grant deed that shows your title to the house. And the major difference would be having a section down below here that name beneficiaries. So that was our talk on documents that we use as part of the estate planning for inheritance planning. Now we will briefly talk about incapacity planning documents. So while we are alive, and when we are alive and well, we have the luxury to plan for when things are not going so well with us, when we're no longer able to care for our own financial and healthcare matters. What can you do now? What can we do now when we're well? So the documents that are involved are power of attorney or durable power of attorney for financial purposes, and healthcare directive for healthcare related or and end of life decisions. And these documents, we sign them when we're well, and when we become incapacitated, they're still valid because the whole purpose is so that we can have agents that we named jump in and help us. And when we pass away, these documents will lose validity because at that point, the inheritance planning documents, the wills and trust, will come in and determine things for us. So power of attorney and healthcare directive documents are also an important part of our estate planning. And earlier in the true or false questions, we talked about estate planning is for everyone. So even if someone can say, oh, I don't own much or I'm quite young, this the incapacity planning documents are still relevant, because life happens, and it really is a good thing if we have a plan in advance. And these documents allow us to plan for incapacity by naming our trusted people to make necessary financial, personal, and healthcare decisions. We're talking about filing tax return, paying utility bills, and healthcare decisions, communicating to doctors about certain medications we're allergic to, we can't use them, and it could be very detailed and very, very practical. So these documents also allow us to describe our desires about the future, what to do in a case of coma, and whether our agent, should help us make decisions about annual gifts. This has to do with some tax-related planning, and also their preferences about whether we want to stay home as long as we want, or whether we're okay with moving to a care facility if we reach a certain stage, and things of that nature. And the purpose of having these documents in advance is to avoid expenses and potential conflict within the family, and the expenses that's associated with conservatorship proceeding, which we will talk a little bit more later. So for durable power of attorney for financial purposes, there are different kinds or different things that we can do. Let's see, go back one. So the parties are principal versus agent. We, as the people who draft these, or we prepare these documents with the attorney, we are the principal, and the trusted people that help us when life happens, they are the agent. And there are springing versus imminent, so these specific terms, just to have an idea. And later, when you're actually doing these documents, you can discuss with the attorney about more details. And also, you can limit how many how much the authorities you relinquish, you give to your agent. You can have the agent take care of everything, or you can give them power to take care of certain things. For both the power of attorney and healthcare directive, there are similarities. So it's good to always have several people in mind to name as your agents in case the first person is too far away or not available, or for whatever reason can't help you when the time comes. And it's probably a good idea to choose someone who's assertive, who can protect your best interest the best. And also, sometimes people want to have several people or all my children acting as co-agents and act jointly. Usually not a great idea, but you know, it's really depending on your family dynamics and specific situation. The good topic to discuss with your estate planning attorney. And you want to also consider the proximity of your agents and whether they are easily available. Agents have to be adult, and so in power of attorney, the agent is called the attorney in fact, and in the healthcare directive, they're called healthcare agent. And it's also a good idea to periodically review your documents and see if there are anything that you want to change. You can make amendments or new set of documents. And when there's life-changing event that happens, it's good to also do updates. And it's just a good thing to have ongoing discussion with your family about your intentions and desires regarding power of attorney and healthcare directive. Conservatorship is a court proceeding that we're trying to avoid by having power of attorney and the advanced healthcare directive done. So when we don't have these documents and unfortunately become incapacitated, whether it's long-term or short, we can make sound decisions for ourselves, can't even feed or dress ourselves, lose self-care capacities. Then the court will jump in and appoint a conservator to manage matters for us. And again, the court will supervise each action and the decision of the conservator the court appoints. And it's just in many ways, we're not in control of the situation. Who is our conservator and what happens with the decision? So, and it's costly and everything that involves court resources. So we're trying to not have to go through this by having the documents done. And besides advanced healthcare directive and power of attorney, there are also other documents for specific purposes. So you might have heard of a post form, physician orders for life-sustaining treatment, and it's again for very specific circumstances and uses, and it's good to talk to a healthcare provider when there is a need for life-sustaining treatment that's in sight. And also the DNR form is for specific circumstances and need also, and usually for more of a advanced stage disease. And when you see that decision inside, and these are not documents to replace your advanced healthcare directive, but you can certainly reference them in the advanced healthcare directive document. And in the advanced healthcare directive document, there is a section that talks about end of life desires, and yeah, so all these things that will help you to make an advanced plan. This pink sheet is the post form that I just mentioned, just what it looks like. It's alarming color, and if there is a health emergency and the ambulance comes, this is a form to show the first responders about this person's needs and desires. And this is the DNR form. So far we talked about all the documents that are part of a traditional estate planning. Again, power of attorney and healthcare directive documents are only valid through our lives, and they lose value after we pass away. And all these documents, so advanced healthcare directive, power of attorney, and the trust and will, through a lifetime, they can all be changed and amended however many times needed. And it's probably a good idea when life events happen and you make changes to them. After we pass, the trust and will become final, no longer amendable. So when you are considering having your own estate planning done, you can meet with a estate planning attorney and do consultation, talk about your personal circumstances, and if you're married, talk with the attorney with your spouse. And usually the attorney will give you a questionnaire to collect your personal and financial information. And once you provide these information, the attorney would prepare the draft, and you engage in the process reviewing these drafts and make edits as necessary. And once it's finalized, you sign these documents in front of the notary. And when you sign them in front of the notary, they are valid legal documents. But that's not the end of the process, because you have to then fund your trust with your assets. And of all the assets, probably if you're a homeowner, the real property is the most important, and you want to make sure to transfer that piece of property to your trust. And the attorney usually helps you with that. And you get the new deed recorded with the county. And at that point, you funded a trust, and you also want to review your documents here and there, and especially when life changes happen. If, say, a new grandkid is born, you want to add that person's name to the trust, and you can do a simple amendment with your attorney and things like that. So these are some famous people that have passed away without having proper estate planning documents or failed to update them. So for Barry White, I think he was with a long-term partner, but when he passed, but the partner couldn't take from his estate, because his estate planning document still named a divorced spouse. So don't let that happen to ourselves. And it's a good idea to start the process when you're ready, and to update these documents according to life circumstances. So this is our resources page at the end. And for the law library, you see the address and the website, email address, and phone number, and same for HERA resources. We have these ways that you can reach out to us. And again, if you want a copy of today's presentation or the slideshow or both, you can drop your email to the Q&A. And at this time, I will see if there are questions that I can address. So Deborah said, I am concerned about the changes in Proposition 19, reassessment and capital gains, which will force inheritors to sell as the will be enormous. So Proposition 19 came into law in February of 2021, and it's still evolving. There are changes and things that's happening to it, and it forces estate planners to also have different strategies around it. So yes, that's a valid concern, and it's definitely a good topic to discuss with your estate planning attorney in your own estate planning process. The second question, I am married but haven't lived with spouse for 11 years. Am I still considered spouse? And how can I find out if I'm still considered owner, i.e. joint tenancy? Yes, so that's a good question. So regarding your marital status, that's outside of the estate planning law, but it's good to talk to a family law attorney about that. And for trying to see if you are still owning the property with the spouse as joint tenants, you can find out that exact wording from the grant deed of your real property. And if you can't locate a copy of the grant deed in your own records, you can request a copy from the county recorder's website. Regardless of which county you're in California, usually if you go to their website, just Google the county recorder's website and go to their website. There is a place to search the real property document, and you can then search by address or names and find your deed and request a copy either by mail or by email. They will maybe have an option for PDF. So you can then look at the document itself and see how the exact wording is on the document. The next question is, if I put my 401k in the trust, is it protected from Medicare recovery? So good question. 401k, the retirement accounts in general, we do not want to put into the living trust. And just in short, it has adverse tax consequences. So retirement accounts in general, we don't want to put into the trust. But you can still name the trust as a beneficiary of the 401k, maybe not the first level, maybe second. But yeah, so there are ways that we can, there's things we can do to try and protect our assets, and the details to that you want to then discuss with the attorney that you work with. Do I reference my trust in the will? How hard is it to update the will? Good question. So with the trust, which I didn't go into too much detail, but basically, when you have a living trust, you also will have a will that's a simplified version of if you have a will by itself. So this will is called a pour over will. And the pour over will have a place to reference the trust, your exact trust name and the date that it was signed. So yes, you can reference that. And updating the will, usually for will, you want to have a new will, because every will, if you had a will back in 2020 and you want to do another one now, the new one will trump over the old one. And that's why you see the title of the will always being last will and testament, because the newest one will always be the last one by date. So it shouldn't be a harder process than the first time around. It's just you do the same thing over. Yeah. And next question, does it make sense for a trust beneficiary to improve real estate before selling? That is more of a personal preference, I would say. It's not quite a legal matter there. Does the probate court have to identify all family in the bloodline before a public administrator or state can take property? That is more of a probate law question, and yeah, I am not sure about this one, but the purpose of our talk today is to avoid probate. So that's all the questions that I have. If you have additional questions, you could still put in the Q&A. All right, I don't see additional questions, and we are 2 minutes to 1 o'clock. So I want to thank you for all the attendees that have come to our webinar today. And again, if you would like a copy of today's slide and the recording, please feel free to put your email in the Q&A, and it's private. And we'll make sure to send the recording link and slide to your email later today. And yeah, that's it for today. Thank you.